Hi, my name is Chuck Schmall, and I'm a patent attorney at the law firm of Woodard, Emhart, Moriarty, McNett, and Henry. This presentation is an excerpt from a longer live presentation about the America Invents Act, commonly known as the AIA. This particular section generally concerns the procedures and practices for U.S. patent applications that were filed on or after its implementation date of March 16, 2013, but claim priority to patent applications filed before then. Specifically, we will discuss the new rules concerning the timing and procedures for AIA transition applications. In addition, we will discuss when and how to make statements under Rules 55 or 78 to designate that the AIA's first inventor to file standard should apply to an AIA transition application. This presentation is provided solely for educational purposes. Hopefully, it will provide you some practical guidance on how to navigate the new procedures and rules under the AIA. However, since these rules are still rather new, we had to make some educated guesses as to how the United States Patent and Trademark Office will implement them. So there is a possibility that the Patent Office will interpret them differently than presented. If you have a specific question about this topic or other patent-related questions, please consult with an experienced patent attorney or agent.
Okay, this is the different thing, and this is you're going to have to babysit your attorneys through this because this one's going to get messed up maybe, unless you're careful. AIA transition application. What in the heck is an AIA transition application? It's an application filed now that claims priority to a pre-AIA, so before March 16. All right, so a con, div, CIP. Claiming priority to before March 16. All right, that's all an AIA transition application is. Quoting basically what it is. What you're going to have to do is to help the patent office out, because they're not going to know, well, do I need to apply the AIA rules or the pre-AIA rules? So do I need to apply a first inventor system or the first, I'm going to just say first to file system. So they need help. To help them, we have to tell them, no, this has to, even though it's claiming priority all the way back, before March 16, this has to apply the AIA rules because there's some stuff here that there's one claim in here that is not supported all the way back there, so we're going to be treated under the new first to file rules. So that's what the statement is all about. So we're just helping out the patent office. Give you the rationale. Again, if you provide the statement, then you're subject to the 102 and 103 requirements under the new AIA, American Invents Act. There are still some exceptions where you might be subject to the old rules, which really my head would explode. You still have an interference declared and some other weird stuff going on under the old rules. I'm not going to talk about it here because your eyes would glaze over more than they are right now. My eyes would glaze over talking about that. Interference is just kill me. Let's give you an example of a transition application. I file my priority application is before March 16th in this example. I file a con, div, CIP, or a foreign application under 119. That'll go away in a year if the foreign application, because it'll be, 119 won't apply. You only have a year in which to file your U.S. application from foreign date. So we won't have to deal with the foreign applications. But with any of those are considered transition applications. And then it's up to the attorney to decide, well, do I need to file a statement or not? That makes sense? One thing we can get shot in the foot on is especially foreign applications, because we don't know. They might give us something, but we might, as attorneys, might want to ask them, hey, have you added anything to this application or claimed anything new that we might want to file a statement on? So we're going to have to probably change our form letters in that regard.
So this is only for any application with new matter?
A new claim.
Well, that's a new.
It's claiming it can. Let me. The next slides might explain a little bit more. So let me jump over there. Okay. It's the claims matter. So I could technically have new matter in the application as long as I'm not claiming it. If it's a CIP, as long as I don't have one claim in there to that new matter, it's still an old pre-IA application. All right. That's kind of weird. If it has new matter and I claim it, I have one claim 49 is a dependent claim that claims new matter, then it's an AIA application. So just one stinking claim in there. If I go ahead, I can't fix it. So for example, and we'll go through this, if I file an application and I have a new claim in there, say, let's pick, say I add some new matter, I have a new claim in there that doesn't have support back to the earlier application, and I go ahead and later cancel it, it's still an AIA application. It's always tarnished. Once it becomes an AIA application, you can never go back. Okay? So that's where patent attorneys can shoot themselves in the foot there. There are certain situations, there's some questions out there with the statute that attorneys might intentionally pick to go under the AIA rules, but I'm not going to go through that here. So canceling claims is not going to help you. Once the application is filed, it's an AIA application. It's always an AIA application. Even its children are AIA applications, even if they're not claiming any of that new subject matter. So that's why we got to be very careful about this. It's the claims that count. It's not the disclosure. And we'll go through some examples. Some other things. Your attorney could shoot themselves in the foot. Say you had like a CIP application, but you're only claiming pre-IA subject matter, and you're like, in my response, you start claiming new subject matter that's in the new application that wasn't supported all the way back. I could get a final office action real quick because that's changed in the grounds of rejection. So if I flip-flop from a pre-IA application to an AIA application, I'm going to get a final office action. I know you don't have to worry about this. Just want to make you aware of some of the other weird stuff. You got to be very careful about this. That's all I want you to take home about this, and just understand why attorneys are checking this form or not checking this form. And then again, always consider to contain AIA subject matter. It doesn't matter with the preliminary amendment. Now there is a trick. Let me teach you the trick. If I have a con and I want to have new subject matter in there, or I want to play games, if I have any question about my new claims, whether or not they're supported by the original application, because, for example, if I file an application, I file a preliminary amendment with the application, with those claims are technically part of the application on that filing date, so I would make myself an AIA application even though I might not be intending to. If I file it 1 day later, the Patent Office would consider it new matter to the application and would not enter it and would not make it an AIA application. You can ignore that. It doesn't make kind of sense, but just make you aware that attorneys might do things where there's a question of whether or not there's support in the application. They might go ahead and file the preliminary amendments like a day or two later, so they don't run the risk of making an AIA application or contaminating it. Right? Don't worry about it. You don't need to remember it. But just trying to, do more. You're going to be drinking from a fire hose right now from all this stuff. The applicant statement is really plain. It can come in a number of places. One, there's a checkbox on the application data sheet. If you look, I gave you a copy of it. It has it on there. Secondly, where it might come up is you might have to do it in a response or an amendment, or they'll just have a statement and you just throw it in there. It's just in your remarks. You just throw it in there. All right. Show you an example. Here is the checkbox on your ADS form. Normally, do not check this box. Okay. Make your attorney make the decision to check this box. So this default should always be unchecked. All right? Don't be checking this box. Because once you do it, you're done. I mean, generally, you can argue that maybe it shouldn't have been applied or it was a mistake, but then you're going to get a Rule 105 request for production of documents, and you don't want that. So be very careful. Uncheck this box. All right? Uncheck this box. Again, the timing of the statement is 4 months from the filing date, or 4 months from the international stage, or 16 months from the foreign priority application. We're going to default to 4 months from the filing date. Or if you go ahead and later submit new claims, like an amendment, you have to make the statement then when you're submitting new claims. There is no need to identify the claim, what claim has a new subject matter that makes it an AIA, or anything else. It's just that flat, simple statement. All right? So there's no other work that needs to be done. So let's do an example. Hopefully this will make a lot more sense to you. This is a transition application because it's claiming priority before March 16, 2013. Let's say it's a con. All claims are supported by the pre-AIA. They're all just, supported by their earlier applications. This is not like a CIP in any way, shape, or form. You don't need to file a statement, right? There's no need to check the box. All right, let's do another example. Okay, file the application. You have one claim that is not supported by this earlier application. And then statements required within 4 months. You need to have it, hopefully you just check it on the box on your ADS. That's probably the best time to do it when you're filing the application. But you have 4 months in which to make the statement. Okay. Let's do another example. File the application. All the claims are have a pre-AIA date. I go ahead and file an amendment with just one claim, one stinking claim with post-AIA date. I need to file a statement with that amendment at the time I'm making the amendment, assuming it's past 4 months. If not, if it's within the 4 months, then I have until the 4 months for filing date to file it. All right? Does that make sense? Hopefully this makes sense. Go through these examples. Okay, let's do another example. All claims are pre-AIA date applications. One claim has a post-AIA date. I file a preliminary amendment with one post-AIA date claim in it. I go ahead and file a subsequent preliminary amendment going, oh, darn, I messed up. I cancel that post-AIA or AIA claim. Can I fix it? No. I still need to make my statement, so I'm toast. So you might see attorneys might start paralleling out cases. So you might have two cons paralleling. One where I'm like being risky, so I don't mind if I contaminate. I'm just keeping this other one in my back pocket as a safety. So I'm not going to be filing any really questionable claims in there. So you might see that going on. So I just want to try to explain, some of the different strategies that might happen. Okay. You don't need a statement for transition applications ever claim earlier subject matter. So before March 16th, never need the statement. If your application is only claiming priority to everything filed after March 16th, all right, never need to make a statement because they know your earliest priority claim is after March 16th. AIA applies, all right? And then you don't need to do it if I already filed my statement in my parent case. So say I file a transition application right now. I file my statement. Any con, divs, or CIPs off that application, I'll need to file a statement again. All right. You might want to just to refresh the attorney so they know it's an AIA application. So here's an example. Priority applications filed after March 16th. I don't need a statement.
I hope you found this presentation to be helpful. If you have any questions or comments about this topic or any other patent-related topics, please feel free to call me at 317-713-4954 or send me an email at cschmall@uspatent.com.